Leaving a business partnership can be complex, especially when it comes to withdrawing from a limited liability company, or LLC. Whether you're considering an exit strategy or simply want to understand the process, knowing the legal steps and considerations for voluntary withdrawal from an LLC is crucial. An LLC membership withdrawal agreement is a set of rules typically included in a company's operating agreement. It outlines the procedures for handling a member's voluntary departure from the company. This agreement is essential because leaving an LLC isn't as simple as walking away. The withdrawal process involves several key steps. First, you must notify the other members of your intention to leave. This is usually done through a formal written notice that cites the relevant provisions in the operating agreement. Next, you'll need to address how assets will be handled and adhere to any specific withdrawal provisions set by the company. It's important to note that each state has its own regulations governing LLC withdrawals. These rules can supplement or sometimes override the operating agreement. For example, states like California and New York may have specific requirements for written notices and procedures for the remaining members. In Texas or Florida, statutes often prioritize the operating agreement but offer fallback provisions if needed. If your LLC's operating agreement doesn't include withdrawal provisions, you have two main options. You can either follow your state's default procedures or work with the other members to amend the operating agreement to include a withdrawal clause. When it comes to the actual process of leaving, there are typically three primary methods: transferring your membership, selling your membership, or withdrawal due to death or incapacitation. Withdrawing from an LLC also involves significant financial and legal considerations. You'll need to determine the value of your ownership interests based on the LLC's current assets and liabilities. It's crucial to understand that any personal guarantees for the LLC's loans or debts remain binding, even after your withdrawal. There may also be tax implications, depending on how the withdrawal is structured. To prevent disputes and ensure a smooth transition, it's vital to have a comprehensive withdrawal clause in the LLC's operating agreement. This clause should address notification requirements, valuation methods for ownership interests, how assets will be distributed, and any restrictions such as non-compete clauses. In conclusion, voluntary withdrawal from an LLC requires careful planning and adherence to legal procedures. It involves notifying other members, following the operating agreement or state laws, addressing financial obligations, and potentially negotiating the terms of your exit. Given the complexities involved, it's often advisable to consult with a legal professional to ensure compliance with state laws, protect your financial interests, and prevent potential disputes. Remember, a well-planned exit strategy can make the difference between a smooth transition and a complicated legal situation. By understanding the process and preparing accordingly, you can navigate your LLC withdrawal with confidence and clarity.